everyone. Thanks for being here. I'm Liz Hill. I am the chair of the American Bar Association section of dispute resolution. So glad to have you here for today's program, What Attorney Mediators Need to Know About ABA Formal Ethics Opinion 518. I also want to extend a very warm welcome to our colleagues from the American Bar Association Standing Committee on Ethics and Professional Responsibility for being part of this, and to thank them for their work on Opinion 518, which is titled, if you haven't seen it, A Lawyer's Duties to Avoid Misleading Communications when Acting as a Third-Party Neutral Mediator. We don't often have this opportunity to gather all together, so again, thank you for being here today. Many of our members have been asking me, what was our role? What was the section's role in ethics opinions like this one? And the answer is we don't have a role in these kinds of opinions. Sections don't issue ethics opinions. Our role is to do what we're doing here today, to engage with something that's of interest to our members, and to ask questions, right? And to think through the practical implications of for dispute resolution practitioners. So Opinion 518 has already prompted thoughtful discussion within the DR section, and I know that today we will continue those discussions. I'm especially grateful to our panelists for lending their time, their expertise, and their judgment to this conversation, and for engaging with these issues with such care and professionalism. And a special thank you to our moderator, Serviansky. I'm gonna say it right one of these days, Danny, for guiding today's discussion and helping us navigate what can be a complex and nuanced terrain. So again, thank you all for being here, for your care, for your commitment, and for everything you bring to the work of dispute resolution and to the section. So right now, I am very pleased to turn things over to Liz Carter, our membership officer. Liz is going to make a few remarks, and then we'll turn it over to Danny to get things underway. Liz?
Thanks, Liz. I'm Liz too, and thanks for letting me speak for just a moment on membership and the section. So I know we've got a lot of people, 229 right now on this call, and if you're not members of the section already, I want to encourage you all to join the dispute resolution section to get access to these programs and many others, our Practice Development Institute, our Skill Summit, Arbitration and Mediation Institutes, great opportunities for networking. Whether you're a practitioner or a lawyer who's representing clients, the section can be a wonderful opportunity for you to meet people, learn skills, and get involved. So I'm going to put in the chat the link to join the section. You can also see it on our Zoom backgrounds. I'm also going to put a link to our membership survey. This is how we decide what kind of programming we're going to offer the membership. So please take a few minutes after our panel speaks and complete the survey. Reach out to me if you've got any questions. Reach out to Liz1 if you've got any questions. We're really happy to have you. Thanks for letting me speak, and I'm going to turn it over to Danny and the rest of our panel for this great discussion. Thank you.
Thank you so much, Liz Carter, and thank you, Liz Hill, the chair of the section of dispute resolution of the American Bar Association. And I'm your moderator, Danny Serviansky, for What Attorney Mediators Need to Know About Formal Ethics Opinion 518. And to read the subtitle of that opinion, it's about a lawyer's duties to avoid misleading communications when acting as a third-party neutral mediator. This is a program of the ABA Dispute Resolution section and its mediation, educators, and ethics committees. Welcome to everyone here. Thank you to the upwards of 200 people who are joining us today. Thank you to both Liz's, to our section chair, and to Liz Carter, who you just heard from. Thank you to our panelists and speakers. You can see our panelists, who I will introduce in a second, pinned on your Zoom screen. Thank you to the director of the section, Jen Mickle. Thank you to the committees that are co-sponsoring that we've mentioned, and to program planners, Lou Hockman, Gina Miller, Aaron Gleaser, Felicia Harris-Haas, Lisa Timmons, Jeremy Vermilly, Alec Chapa, and Aaron Gotthelf. Our panelists, I'll provide some brief bios. Please wave please wave so that people can see you on their screens, and then we will get started. So in addition to the people that have already been mentioned, I'm your moderator, Danny Serviansky, and I'm co-programming officer of the section and co-chair of the Education Committee. Our panelists, John Barquette, partner at Shook, Hardy and Bacon. He is the ABA Litigation Section Liaison to and also a past member of the Standing Committee on Ethics and Professional Responsibility. We have Professor Stephanie Blondell, Professor of Law and Practice and Faculty Director of the Strauss Institute for Dispute Resolution at Pepperdine Caruso School of Law. Then we have Tom Wilkinson, member at Cozen O'Connor, a member of the ABA Standing Committee on Ethics and Professional Responsibility. And at the Pennsylvania Bar Association, he is past president and past chair of Legal Ethics and Professional Responsibility. Then we have Kathleen Wilkinson, senior counsel at Wilson Elser, also at the Pennsylvania Bar Association. She's, correct me if I'm wrong, a past president as well as past chancellor of the Philadelphia Bar Association. Lastly, we have Rich Burke, senior vice president at James, executive director of the James Institute, and chief architect of James Pathways. Let's get started. Stephanie Blondell.
Hi,
You know this
thank you.
material. You know the material as a moderator, as an academic, as someone in ongoing dialogue with the profession, with people who are practicing this every day. Please get us started. Stephanie, please tell us about Opinion 518.
I will tell you, I have been tasked with doing an overview. And so that is what I'll do. I'm going to do it chronologically through the opinion. And then hopefully I'll be a harbinger of things to come as we hear from people, authors of the opinion, as well as a lot of other people who have really rich perspectives. Rich is going to talk about how this leads us into the next stage of dispute resolution. And so I'm hopefully setting it up for that. Before we do that, I'm gonna project a slide here and talk a little bit about the source of mediation ethics. I'm not going to go into a lot of detail, but just so you can kind of get your head set. What are we talking about here? Okay. And as we as mediators look at the source of our ethics, there are so many different sources of ethics, right? The rules of professional conduct, and that's what we're going to be talking about today. So we're going to swing back around there, but we also have the model standards, statutes, codes, court rules, rules of evidence. Professional and volunteer organizations have adopted often one of these rules in order to create expectations from the community. We are a relatively, as you know, unregulated practice. So there is also a sense that we hopefully have internal codes, that any ethical code is really the basement, but that we all might achieve aspirational ethics as well. So this is our source of mediation ethics, and we're going into the rules of professional conduct. And what's particularly, I think, well done in this opinion, in general, I can just say wonderful things about this opinion in terms of explaining, teaching. I think it's well written and reads as a teaching opinion to help people understand what they're doing. But what I can say about it is the first section just really walks us through what are our obligations. So I'm going to go ahead and do this, like I said, chronologically in the opinion. This is divided into section 1, 2, and 3. Okay. And again, just to get our heads around it, if it's been a New York Minute since you read it, when it came out in October, it does arguably kind of two things, but it's divided into 3 sections. Number 1, the lawyer mediator's duties under Model Rule 2.4 when serving as the third party neutral. Number 2, the lawyer mediator's duty to avoid statements that imply the lawyer mediator is not neutral, but is seeking to achieve a party's best interest. I think that has emerged as the most kind of discussed area of the opinion. Well, I think first reading, most people had more to say about number 3. The lawyer mediator's duty to avoid dishonesty, fraud, deceit, and misrepresentation when communicating with the parties. Okay, so those are the 3 different sections of the opinion, starting with the first, which is going through model rule 2.4. The opinion starts out by pointing out what I think is obvious. This applies to lawyer mediators, but it's really helpful and it gives me good language to bolster my teaching. Let me stop sharing here, folks. Did I stop sharing? I did. Thank you. Appreciate it. Okay. So the opinion talks about how the rules of professional conduct apply to largely lawyers in their representational capacity. Okay. And there's a few rules that apply to the lawyer working in the role of the neutral. There's also a host of rules that apply to lawyers in any capacity, right? But this opinion really takes those rules that are focusing on the role of the neutral, the lawyer acting as a neutral, and walks us through them, okay? So the first one in rule 2.4, and I can share 2.4 here. To remind you, this is one of our very few guiding lights as mediators, and here it is. It gives us the authority to serve in this role. And then section B says, a lawyer serving as a third-party neutral shall inform unrepresented parties that the lawyer is not representing them. When the lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third-party neutral and a lawyer's role as one who represents a client. Now, I think this is probably something that's not going to change a lot of people's practice. It will perhaps bolster my teaching, but what the opinion does is it goes into further detail and gives a little bit of an example to help us know how to do that. Okay, so I'm going to go back to the opinion language here and quote from the opinion. Unless the parties are sophisticated consumers of mediation services, it is prudent for the lawyer mediator not only to inform all parties that the lawyer mediator does not represent them, but also to afford them an opportunity, and this is the key part, I think, to discuss what this means. So it's not enough to say, I'm not a lawyer, I'm serving as a mediator, right? Which I think in some contexts, certainly in the boardrooms of Century City, might be sufficient, and that's an LA specific comment because that's where most mediation happens, but that's sufficient in many contexts. But I think the encouragement is even in that context to say more and to discuss. That is good practice. Will not change my practice at all. I hope it won't change your practice at all, because you should be doing these things to begin with. Okay. Section 2. Let's look at section 2. There's always an from me when I'm multitasking with tech, so you're hearing it here. Okay. This second section is, I nicknamed the first section kind of role clarification. The second section I've nicknamed legal info, legal advice, and kind of our duties. This particular section, I think, has turned out to be the most controversial. And for those of you that haven't seen the excellent discussion between Ellen Waldman and Jeff Kitchaven and Will Work for Food, I encourage you to check that out because it's a really rich discussion. And Ellen has cited this as part of what she thinks is the most important part of the opinion and is also doing some writing on it, which is really smart. It's really smart, and I can't wait for it to come out. The lawyer's mediator's duty to avoid statements that imply that the lawyer mediator is not neutral, but is seeking to achieve a party's best interest. So under the model rules, the lawyer must act in the client's interest. And now what's become controversial about this, I think, is this word to achieve a party's best interest. And it looks as if the authors of the opinion are grabbing that language from the rule, as they should. And because that is a lawyer's duty. It has lay meanings within our field as mediators. It implicates how we see our role, our mediator persona, and I think that's what's caused a lot of conversation. And we'll discuss that more. But under the lawyer's model rules, the lawyer must ask in the client's interests. Various provisions of the model rules give expression to that responsibility. However, that is not the role of the lawyer mediator. And this is language from the opinion. The lawyer mediator's role is to assist the parties in resolving their dispute, regardless of where the interest of a party may lie. Okay, I'm going to return to that in a moment and talk about the second part, but it's that last little phrase at the end that I think has sparked a lot of conversation. The obligation to avoid misleading the parties about the lawyer mediator's role also means that in conducting the mediation, the lawyer should not state that the lawyer mediator is acting to achieve a party's best interest, or that a proposed settlement is in a party's best interest. Isn't this interesting, right? Okay, we're going to go on to one final final quote from the opinion. It is not misleading, however, to provide legal information or to discuss the parties' respective views of how a tribunal would resolve a legal or factual question. It has a footnote in there. 6, a mediator might offer an opinion as to how a tribunal is likely to rule on an issue, but the lawyer mediator should not state or imply that a settlement is in the party's best interest, because a tribunal is likely to decide adversely to the party. New paragraph. If a party, particularly an unrepresented party, requests that the mediator provide legal advice, the mediator should again explain the mediator's role and advise the party to seek legal advice from counsel of their choice. Okay, now what this particular section does is it starts out by talking about the importance of the lawyer mediator acting within their role and not seeping into that role of attorney by saying this is in your interest. Okay, that's what section 1 does. Section 2 then goes on to talk a little bit about legal information and legal advice, which many of the rules have not touched at the ABA level. A lot of court rules in states and particular jurisdictions have gone into that area, but this is new. Now, why has it been controversial? I'm going to just highlight it very quickly because we have to move on. But I think that many people think of their role as mediator increasingly as we talk about the development of multi-partiality or omni-partiality in the field, as advocating the party's interests as much as possible in one room and as much as possible in the other room. And so I think there's a confusion of terms that people are kind of clinging to, maybe overreading the rule and saying, but wait, this line that says, essentially, let me go back one. This line that says, and I'll read it to you, the lawyer's mediator's role is to assist the parties in resolving their dispute, regardless of where the interest of a party may lie, left some mediators feeling cold. Like, is that my only role, is to help them get a deal, to be a settlement officer? I see and define interests more broadly than that. So this is putting me into the category of being in the shadow of the law. For those of you on Riskin's grid, very narrow, when I see myself as a broader mediator. Others have gone in different places. Jeff Kitchhaven, if you have time to watch that video, talks about how this implicates mediator proposals. Really interesting. Let's move to 3, though. I got to move on, right? Danny, I'm moving on. I promise. I'm just giving the overview here, though. Lots of opinions going on in here. Okay, this third one I've nicknamed puffery. And this one essentially deals with the lawyer mediator's duty to avoid dishonesty, fraud, deceit, and misrepresentation when communicating with the parties, and sends us back to the rules. This is the heart of, for me, the opinion where I just go, oh, phew, I'm so glad you're saying it. Because I often have folks that I interact with, I think, misunderstanding their role as a mediator, especially a lawyer mediator, and thinking that they have the same license that the lawyer has to puff in negotiations. So this is a really welcome clarification. If we want to look at 8.4c, I think this is probably true in all states that have adopted the ABA verbatim in terms of allowing a mediator to, allowing a lawyer to puff as to bottom line, right? And my job is I teach, probably about 1,000 different mediators a year, and they are commercial mediators coming to become, they're commercial lawyers coming to become mediators. And this question of, is the mediator allowed to puff in the room? I have heard people be really misguided on this particular issue. What the opinion says is that the lawyer mediator must be thoughtful and cautious in communicating information from one party to another. So we know there's puffery going on in each room, right? We know that. But can we convey that puffery is the question. A lawyer mediator must be both thoughtful and cautious in communicating information from one party to the other, and in answering questions that may be asked about the information communicated or how the lawyer mediator views the information. For example, a lawyer mediator may not make a statement that the lawyer mediator knows to be false, that this is the best offer the opposing party will make. So it's the age-old, last best final. Is last best final last best final? Well, we all know last best final is not last best final, right? So the lawyer mediator must be careful not to make misleading statements about the strength or weakness of a party's case. And this is particularly true when you have unrepresented parties. What I will say about this is that the opinion, and then those that have written, Robin Weinstein wrote another absolutely wonderful piece that's on the AAA site right now, and we can post that at some point, where she kind of goes through some language and looks at the language. What we know is that the opinion is telling us, yeah, don't lie, don't puff. You're allowed to as a lawyer, you're not as the mediator. You have a higher ethical, your role implies a different relationship to the truth, and that you need to follow through with that. The opinion talks about this last best final offer issue, but I think what it leaves open is some really interesting issues about, what happens in the commercial mediation room when they say, don't tell them the client isn't here. Don't tell them the client left. Don't tell them that we lost the evidence. Don't tell them, like, all of these things that happened. We have confidentiality, which is fascinating, butting up against people asking us to carry information that might influence. Now, the negotiation dance. Now, why this was controversial, I think, to begin with when people read it, and why I thought on first blush after reading this that this was the big one, is I almost overread it to think, oh, does this mean that I'm going to interfere with the dance of negotiation that we all know has this ritualized puffery embedded in it? And no, that is not what the opinion says. The opinion asks us to be doing what I think we should be doing anyway.
Stephanie,
and I must ask this, and I'll stop with this.
I'm going to jump in for time.
Why would it be a good technique for a mediator to give credence to statements that are false anyway? You need your credibility at the end of the day. So that it kind of begs the question. I have done my 10 minutes, and so I am going to stop.
Thank you, Stephanie. So you
Daniel,
gave
you
us.
are muted, or we just can't hear you. No, is that just me?
It might just be you,
It's
Stephanie. I
just
think
you,
Are
we
we
can
you?
hear.
Please give me a nod if you're able to hear me. Okay. So let's thank you, Stephanie. And I apologize that you can't hear me right now. If there are other people in that position, please let us know in the chat. We're turning now to Tom Wilkinson. Tom, you're an attorney mediator, an esteemed member of the bar, a member of the ABA Standing Committee on Ethics and Professional Responsibility. Stephanie has us thinking about the differences between the role of an advocate and the role of a mediator. We want to turn it over to you. Please share your thoughts.
Well,
Moving
thanks,
forward.
Danny. I really thought Stephanie's overview of the opinion was outstanding. I wish when we were working on the opinion that we had as many thoughts in our heads as she's already relayed. I'm not permitted to get into the committee's deliberations. That would be contrary to policy. All I can say is that I'm personally pleased with the opinion. I think it's nice, short and sweet, and provides helpful guidance. But at the same time, I think it's modest guidance for lawyers serving as mediators and really builds on the previous guidance that the ABA issued in Formal Opinion 06-439, which relates specifically to lawyers advocating for clients in the context of mediation. You have to realize that when the ABA model rules were adopted, roughly 50 years ago, there was very limited guidance. The mediation was a lot less prevalent than it is today. And Rule 2.4b was helpful, and there has been very little from the ABA since. The ABA did sign on to and approve through its policymaking body, the House of Delegates, participation in the model standards for mediators, which were adopted in 2005 and are referenced in footnote 4 of the opinion at page 3. And they're of course excellent and provide other guidance, including guidance with respect to the direction to avoid and to disclose conflicts of interest, which I think is an ongoing issue for parties and for lawyers to support the integrity of the process and the confidence in the process. So the goal, of course, is not to interfere with or to undermine the various approaches and ways in which good mediators um, uh, generate great results. Some engage in gentle prodding. Some are more aggressive, press harder, and more tenacious. And this doesn't, in my view, undermine mediators' freedom to tailor communications in a manner they think will be most effective in bringing the parties together. But as Stephanie noted, there's a difference between giving legal advice or appearing to give legal advice when you're a lawyer mediator and your role as a true neutral. Many mediations may arise in the context of unrepresented parties, unsophisticated parties, and those people need not only a disclaimer at the outset, they may need multiple disclaimers as the process goes on to confirm their understanding that your role is limited, that you're not giving legal advice. With respect to the arguably controversial piece, which is the reference to not stating that this proposal is in your best interest. There are certainly ways around that. It's the same thing as conveying a proposal from one side that is to the effect of, this is our last and final offer. This is we won't put another dollar on the table. We're not going to change our position. All you have to do is convey that that's the other side's position. You're not adopting it. You're not underlining it. It's not your position. It's that party's position, and disclaim that it's something that you're proffering in that manner. And especially under circumstances where you have reason to believe that's not truly their last and final offer or their final position. If you've learned in a caucus set or in a private setting that they in fact have more money that they could put on the table or are potentially amenable to other conditions of settlement, and then you say this is the last and final offer, you've engaged arguably in a misleading communication that could violate the Rule 8.4 portion of this opinion, because it doesn't just deal with the Rule 2.4 directions for mediators particularly. So I would say that without trying to repeat anything that Stephanie did, which was really excellent, I would say you're not going to knowingly convey or endorse false statements. And at the end of the day, it's great to have a discussion about this and to focus on what the potential limitations are, because perhaps some mediators need a reminder that they're out there. And I would also note that David Hoffman posted his excellent piece in the chat. I had an opportunity to discuss with David his views about the opinion before he published them, and I would say that he really did a commendable piece and great summary. In addition, Robin Weinstein did a piece called Taking ABA Ethics Opinion 518 for a Test Drive. That was published for the AAA. Also a great summary. And there are perhaps permutations and close calls that can arise from time to time when you're in the midst of discussions back and forth. You know, take a breath. I know you want to get it done, but don't overstate your position. Don't so align yourself with a particular party's position that a party will understand or misunderstand that you're advocating for them. And if there's some confusion, some misunderstanding, some need to reiterate your role as a neutral, then do so. Don't be reluctant to do that. Don't think it's going to derail the posture of the matter, because you don't want to have people upset at the end or perhaps challenging the outcome because they feel you improperly leveraged your position, particularly when dealing with an unsophisticated or unrepresented client. So that's my contribution, and I want to again thank Stephanie for the great overview.
And thank you to you, Tom. I'm noticing that we are getting resources and questions in the chat, and I want to encourage everyone to continue to do that. Thank you to all. We have some esteemed colleagues commenting, and we will address as many of the questions as we can at the end of this segment where we're going through initial comments from each of our panelists. Again, thank you, Tom. We're going to turn to John Barquette. John, you also bring extensive experience from law, mediation, and particularly in professional responsibility, including tours of duty on that same standing committee on ethics and professional responsibility. Please help us understand the ethics opinion process and the issues that this opinion brings up as you see them. John Barquette. And John, you're on mute right now.
According to the schedule that you sent us, my remarks have already concluded, so maybe we should just move on to the next speaker.
In the style of a soccer referee, I've determined that you have your time in full at the moment. Okay. Please go ahead.
There have been a lot of penalties. I get it. Okay. Welcome to all of you. I'm impressed by the numbers on a Friday afternoon, but thanks for joining us. So the process is really not complicated, and you can probably imagine what it's like. Someone has an idea for an opinion. You sit, well, now we sit by Zoom, but you sit in the committee and there's a question raised by the chair. Does anybody have ideas for an opinion? And someone will say, yeah, I think we ought to write something about the lawyer mediator in 2.4. And the chair will say, will you prepare a working draft to circulate? And whoever made the proposal will say yes, because you don't raise the proposal unless you plan to do that. And then the draft gets written and gets circulated. There are what, Tom, 6, 7 committee members? I've lost track of the actual number. And then there are liaisons from various ABA sections. I don't know if the ADR section has a liaison, but you're certainly entitled to have one. And as was mentioned in the introduction, I'm a liaison now from the section of litigation. And so somebody proposed this particular topic, a draft was circulated, and then it gets vetted at 1 meeting, 2 meetings, 3 meetings. And I think this one was vetted over several meetings, as I recall. I know we all worked on editing, and then it gets to a vote of just the committee members. And if they vote to approve it, then there's a final scrub by the committee chair and the ABA liaison, the staff person, and then it gets published. So that's the process, very straightforward. Tom being a mediator, me being a mediator, we were able to offer a lot of insights. And, listening again, having worked on the opinion, having read the opinion, and now having listened to Stephanie describe the opinion, I'm still not troubled by any of the words. I'm not sure what all the to-do is over. I'm a big believer in the principle of self-determination. So what's in somebody's best interest is something for the party to determine, not for the mediator. That doesn't mean, as Tom pointed out, that there aren't ways to communicate. And I can recall numerous situations where I've encouraged parties to look very carefully at a particular proposal before they walk away from it. And of course, we always consider what's the best alternative to a negotiated agreement. And if it's a judge or an arbitrator's decision, parties have to make that determination. I did mention in our planning that there are always tricky issues for me as a mediator, and I'll just note them. I'm not going to pretend to always have solutions, but situations where you know that counsel is really not doing a very good job for a counsel's client, say not aware of case law that's material to the outcome, for example. I've faced that situation. I've been in situations actually described in the opinion where summary judgment motions were pending, and offers were made that really should have been accepted, but weren't, where I've talked through with counsel the likely outcome of the summary judgment, really just by asking questions, not by predicting. And certainly, how do you deal with those kinds of situations? I don't. Is that a rule of professional conduct question? Is it a model standards question, or is it everything I ever learned in kindergarten question? And so, I just try to follow my nose and use good judgment, but always being mindful that mediators don't settle cases, parties do, but encouraging parties to see the strengths and weaknesses in their case. As I tell parties all the time, I don't care if you don't settle, but I do care if you don't settle. And when you get to the courthouse steps, you regret that you didn't settle. So it's my job to make sure your eyes are wide open. It's your job to decide whether you want to resolve the case or not. And I think that approach is very consistent with everything that's in this opinion. So with that, I'll turn it over to maybe, I guess, it's Kathleen, and leave some time for questions, hopefully.
And thank you, John. And of course, we can pick all of this up during the questions. And I encourage everyone to start looking. We do have questions coming in on the chat. Kathleen, as John said, it is time to turn it over to you. And I know you've talked about the values and overarching themes that you want mediators to have in mind as they relate to this opinion. Floor is yours.
Thank you. Absolutely. So humbled to be part of this esteemed group of people and to be talking about this very interesting topic. I practice both in New Jersey as well as Pennsylvania. A little bit about my background is that I not only participate in a multitude of mediations and settlement conferences, but I also serve as a mediator as well as a special discovery master for state and federal courts. So I've seen both sides of the table, so to speak. And I can tell you that one thing when I am acting as a mediator or as a discovery master is I insist on professionalism. And I think I want to bring that up right now because of what was just said by John about sometimes people not taking things seriously or perhaps not taking advice seriously that they're giving to their own client, their client's acting out. So if any attorney or their client starts acting out, I try to remind everyone that, we are here to resolve the case if we can, that I don't want to see the lawyers fighting with each other. I want them to speak professionally to each other as well as professionally to me. So that's my overarching desire, that we be professional at all times. With regard to the types of cases that I've handled, not only as a mediator, but also as an attorney, you definitely have to be extremely cautious when you are a litigant and you're representing your client. We can't talk in terms of this is our final offer or, this is their best demand that they're going to make. We shouldn't even think about those words or use those words at any time. And when I'm serving as a mediator on the other side, of course, the things that John just said is absolutely true. They, regularly you hear that they're not going to go down another penny. That's it, forget it, what have you. So you can't depend on those phrases. So you have to be very careful in what you say. And you also have to be very careful in what you're saying in the mediation statement. We haven't talked about that, but a lot of times in those mediation statements, which in most cases are confidential, maybe there'll be a non-confidential one exchanged just about the facts of the case or the alleged facts of the case. But we should be cautious also in what we're stating in our mediation papers as well. And also in the role as a mediator, I'm not giving advice to anyone. I clearly understand that. Yet when I'm a litigant, I'm doing the opposite, right? So as a mediator, I'm very cautious as to what I say. I simply convey, what the offer is without sugarcoating it. But if they ask me questions, is that the best they're going to do? And I always have to say, no, I don't know. I can't judge that for you. This is what they say. These are the reasons. I always try to get the reasons. These are the reasons that they are telling me that they are making this offer. But what I have to confirm before I tell that to the opposite party, that I'm allowed to share that information with them. Because we as mediators, when we serve as mediators, we're in a confidential setting. And a lot of times the litigants will speak very freely and they'll reveal a lot of information that they don't want me to tell the other side. So we have to be very cautious as to how we're representing the information to the other side. So I always have to ask, do I have your permission to say XYZ and confirm it back with them? In addition, in terms of, when we hear a mediator giving an opinion, when I'm a litigant, I try to ask the mediator, is that your personal opinion or what are you relying on that? Why are you saying that? And sometimes it'll be a judge who's serving as a mediator, and the judge will say, well, I've had experience in this area and I've seen a case where they rule XYZ. I don't think your motion for summary judgment has any merit or little merit. And that's kind of helpful for me to know, because then I can go back to my client and say, there's bad case law out there. Apparently there's a recent case that was just decided. So we have to take that under consideration. So we have to be cautious if we're in the opposite point. If the litigant asks me as a mediator, well, what do you think? I have to be very cautious about that, because unless I have permission from the other side to reveal something that they told me, or if I have firsthand knowledge of something, such as a case. Maybe I'm familiar with a seminal case in Pennsylvania or New Jersey, and I can say, well, there is this so-and-so case, because maybe I read it in the opposite, opposing party's brief. So in conclusion, we must be very cautious. We can never represent at any time. Also, I shouldn't be the one trying to negotiate. We talked about the mediator's role is not to negotiate the best settlement, right? I agree with that 100%. Our job is to try to resolve the case if we can. That's our job. And our job is to make each side also understand that, you're going to spend more time and money if you keep going with this case. So that's always something, generally speaking, that can be said. And lastly, in the discovery master context, there it's a little bit different approach, because there I'm representing the court more, and I'm being asked to make recommendations to the court about what I think the court should rule. So I'll tell the parties that, your answers to interrogatories are really very poorly drafted. You have this, you have this, you have this. I plan to recommend to the court that you do X. I would suggest that you try to resolve it now and then give me, your amended answers, and then I can take that under advisement. So I try to help the parties maybe change things before I go to the court. But I'm also telling them, if I have to go to the court, then I'm going to recommend this, and I tell them beforehand. So I hope that gives you a different vantage point, because I have two sides to myself, both mediator and litigant. Thank you.
And thank you, Kathleen, for bringing those two sides of your extensive expertise. Perhaps you were referring even to a third there. And, it's intriguing to hear you talk about contexts where there's a duty to advise, in contexts where there's perhaps a duty not to advise, and then in contexts where you're signaling what you might do, given that in that context, you do have the power. So, Rich Burke. Last but not least, few people have as broad a view of mediation in the field as you do. Please share with us how does it look from your end for the practice of mediation and for what the future might bring. Rich.
Well, thank you, Danny, and thanks to all my guests, co-presenters. I had a page of notes, and I've been scribbling on it because everybody's been saying such wonderful things. My original task was to talk about trends in mediation and how 518 fits, and then leading to a prediction of the future. So a little bit of my background. My first mediation was 35 years ago, and the first time I taught a mediation course was also 35 years ago. I was a lawyer for, this is my 40th anniversary of graduating from law school. So there are folks who've been around the block a little bit more than I have, but I've been around a few times. And so what's different between now and 35 years ago? Well, originally 35 years ago, when mediation was relatively new, mediators got to kind of run the show and lawyers just listened to you. And you said, Gary Friedman could say, I want to do no caucus at all. And lawyers said, okay, we're not really sure what that means, but sure, we'll do it. Well, things have changed over time, and lawyers really run the show. It was probably 15 years ago where I saw an advertisement for a CLE program called How to Spin the Mediators, right? So mediators are on notice that lawyers are sophisticated. Lawyers choose mediators carefully for different characteristics depending on the case. And so it's pretty clear that the process is more lawyer-driven than it was quite a while ago. Additionally, something else that's changed is the market is, as we all know, incredibly competitive. Lots of organizations, Pepperdine included, my former law school where I taught for 25 years, we produced an awful lot of mediators. And a lot of folks did transition to the world of mediation. And that means that we all have competition. Even within my current organization, JAMS, you have a choice between various JAMS arbitrators or mediators in any jurisdiction. And so there's a lot of competition. Now, what does that mean for us? It means that in order to be a successful mediator, you really need to be very, very good because a bad reputation will spread incredibly quickly. And so the notion that we aren't up on our training, the notion that mediators are unsophisticated in some way, that they just sort of join the profession because they're burnt out with what they were doing before, I think that that's not true. I think that mediators who are going to be successful are incredibly well trained and they are incredibly aware of their reputation. And so many of the things that we talk about, like the idea of misrepresenting or puffery or engaging in the sort of behaviors that a good litigator might do, that would be anathema to a successful mediation career because the market is terribly unforgiving. Now, in addition, mediators, as a result of market forces, have become much more sophisticated. The notion that you would say it's like that's their final offer means that you have wholesale believed something that a lawyer has told you in a room. And if you have seen that How to Spin a Mediator CLE, or if you have been in a few mediations where there are 3 or 4 consecutive last best final offers, we know that we say they say it's their last best final, and we can go back to evidence and talk about inferences. We can say, well, they are packing their bag. I don't know if that's a ploy or not. If that's the inference that you can draw. And the other thing I don't see is any clumsy predictions of what a court would do. So 2/3 of our panel are retired judges, but quickly, a year or two after you're off the bench, everybody knows that the lawyers may know more about predicting what a court might do than you can predict what your former colleagues could do. And in addition, anybody who sat on an appellate panel knows that you can't predict what your colleagues are going to do in a given day. Forget about a couple of years later, right? So this notion of saying this is what's going to happen in court and this is better for you than that, I just don't see that. Now, in addition, I'd like to make a comment on the idea of evaluation and facilitation. And, many years ago, I wrote a piece basically saying, can we get past this either or? Because for me, every mediation comes down to 3 basic questions. What do you want? What's available? What happens if there's no deal? For those of you who are getting to yes devotees, you can see those are interest options in BATNA, but I moved away from the terms. So if we're talking about what do you want and you're trying to craft a deal, well, clearly you are facilitating a dialogue because I don't know how you evaluate your way to a new deal. And on the other hand, you're comparing it to what happens if there's no resolution, and you're putting a price basically on if we go to litigation. How much does it cost? How long does it take? What am I likely to win? Right? And so we are putting a price on the walkaway alternative. And if you are valuing something, you are engaged in evaluative activity. And the range of evaluative techniques ranges from everything from like cocking an eyebrow when someone says something that's a little bit strange to you, all the way out to, I guess, making some kind of crystal ball prediction of what's going to happen in court. But I don't think that crystal ball prediction is going to be good in the marketplace, and it's not going to play. Right. So I think what we do in evaluation, we ask a lot of questions, and on the facilitation side, we facilitate dialogue. So every mediator is evaluative and facilitative, whether they are explicitly that way or not. Now, when we get to evaluation, you can do it clumsily in a way that would violate 518. But again, I think market forces will rein you in. What else has happened in the last 35 years? Well, mediators' proposals are a big deal. We didn't see a lot of mediators' proposals 35 years ago, and we see quite a few of them now. There's a lot of debate. There's a lot of real interest in kind of, why that is the case. And we all know, those of us who've mediated quite a bit know it's easier to bridge the first $5 million gap than the last $5 gap. Nobody wants to make that last concession, so there are some psychological issues around that. But one of the issues about mediator proposals is every mediator that I train and every mediator I think that's worth their salt starts with the admonition before they even think about a mediator proposal is this is not my prediction of what would happen at trial. This is, having been in all the rooms today, a sense, maybe a misguided sense on where the case could potentially settle and leave you all better off than continuing to litigate. Well, first of all, let me remind everybody who thinks that somehow that is a prediction of court outcomes or that it is sort of making a statement in violation of 518. A mediator's proposal is a proposal. It requires that the parties, in conjunction with their lawyers, consider it against all the other options and alternatives and agree to it. And so the notion of making a proposal somehow is like, is equivalent to the statement, this is in your best interests, and I have to split the middle. Now, I want to also take on one other point. I have had a long and wonderful relationship with Jeff Kitchaven, and I still value our friendship. We don't see each other nearly often enough. I love that he's willing to make some bold statements, but I would take issue with one thing that he's said with respect to mediator proposals, that you either have to pre-clear or have to split down the middle. And the splitting down the middle suggests that we're talking only about dollars. Right? Because if somebody's offering $10 and somebody's offering $20, it doesn't take a PhD engineer to figure out that the middle is 15. But what we're really talking about in mediation is splitting utility, right? The economic concept of what is it that you want out of this. And since we don't have this mythical idea, psychologists talk about a hedometer, which is a helmet you would put on people that would measure their units of pleasure, right? We don't know that a dollar given to one party or another equals, creates equal amounts of pleasure, equal amounts of utility. And I think what we're doing as mediators is not just splitting dollars, because that's just an insult to our profession, right? When we're resolving matters, we are doing something much broader than just splitting numerical amounts. And so what we're doing is really asking people, what do you want? What matters to you? And so, of course, if we're trying to split hedonic pleasure, that's an artistic, not a specific scientific calculation. And so I am really grateful that 518 left enough room that we can do that. Now thinking about the future, I spend a lot of my time. I'm the education director at JAMS, and so we train an awful lot of people. And so I've asked myself, as a result of 518, am I going to change the way I teach? And racking my brain and always looking for some way to improve. And my reading list is very long, even after this 35 years. I'm not seeing any changes in the way I'm going to train my people. So that leads me to my final, my final point is that there's a relationship between rules and norms. And so we can have, let's just say, my first job out of law school, I was a prosecutor, and there was this law that says thou shalt not murder. It doesn't use those terms, but we get it, right? There's an admonition against murder, and yet murders occur. And so the relationship between the law and the norm is that the law is aspirational and it tries to move people in a direction toward fewer murders. There are other times, like let's say, the Uniform Commercial Code, where what they try to do with respect to the creation of a law is to capture a norm that's actually happening in practice so that that norm becomes widespread. It becomes known outside of the inner circle of the community. And I think that that's what 518 and many of the really good ethics rules that have been promulgated by the ADPA do, is they capture the norms of what's happening in the sophisticated ends of the practice. And so, when we see, for example, there was a rule that says, don't use client money as if it was your own. Well, I'm hoping that was capturing a norm that was true among good practitioners and not trying to say everybody's doing that. We need to make a change. And so I think what 518 basically does is it says mediators need to be neutrals. And neutrality is the hallmark of our profession and the hallmark of everything that we try to do, at JAMS, and I'm sure in all the other organizations to which you belong. And, so for me, 518 captures a norm about what sophisticated practice looks like now. And if you are a sophisticated practitioner, as a practical matter, it basically endorses what you've already been doing. If you're a newbie in the field, or maybe you're a heavy-handed person in a small claims court or a jurisdiction in which you're dealing with a lot of unrepresented parties, it gives you some really important guidance about how to enter this profession. But for those of us who've been around the block a couple of times, I think it basically captures what we've already been doing. So, a lot said quickly in a short period of time. And now turn it back over to you, Danny. Thank you for inviting me, and thanks for everybody in the chat and co-panelists for your participation.
Thank you so much, Rich, and thank you to all of our panelists. Take a deep breath, panelists, as we move into questions and discussion. It was a pleasure and an honor to watch that collective tour de force discussing this opinion. And as Rich was pointing out, and as Stephanie started out with, it really is a tour of our profession and of writing down and identifying some of the things that, as Rich said, sophisticated mediators have in mind. And I want to thank everyone here for getting us started in this conversation. I know it's just the beginning of a conversation that our profession will continue to engage in. Our chair, Liz Hill, has summarized some of the questions that have come in over the chat. And I'll start simply posing them to the group. And panelists, please feel free to provide your own questions and or comments. And let's see where this conversation goes. Liz, I'll also say thank you for sending these my way. If you prefer to jump in and provide any of them yourself, please go ahead and do so. I see that you've unmuted there.
No, I was just going to say thanks for the offer, but take it away. You've got this.
Absolutely. So let's get started. Panelists, we had a question come in about what happens, about what you would do or suggest that a mediator do if a party, whether represented or unrepresented, looks at you and asks your opinion as the mediator. What would you suggest that mediators do at that moment when you're asked, what is your opinion as the mediator?
Opinion about what?
A case?
Yeah. Let's say the law.
The outcome or an offer. I mean, we're talking, we're asked our opinions a lot and people are trying to read us. But
sure. I'm imagining, and the person who asked this question, please let us know if you're imagining something else. From the context of our conversations, I imagine it may be quite general. Let's imagine a party, or after long discussion, late into a day of mediation, so having presented facts, having presented arguments, having talked about how they see their interests and define them according to their own measurement of happiness. Rich, what do you think I should do?
If they're talking about the mediator's opinion of the outcome of the case that proceeds to trial, well, I think we go back to Mark Galanter and we know that, 99.4% of all filed civil matters will end some other way than a verdict. And we really just lack the information about what a court might do because we lack the data. Now, parties want to know that they're sort of in the ballpark because one of these unstated interests of every party is to say, I don't want to feel like a sucker later. So, mediators may be able to say, look, it's not my prediction, but does this meet your interest? It seems to be, in the ballpark. But I think a mediator saying it's like a case will come out this way. I mean, look, if there's a person in our listening audience who can accurately predict the outcome of cases, you are going to have a long client list and be able to charge an awful lot of money. I simply don't know a mediator who has the temerity to think that they can do that. What they can do is they can identify risks. They can say, well, based on what you said, you care about, you care about getting back to work and you care about time. I think that, it's obvious the deal on the table will happen quicker than if you continue down the court litigation path. But the actual prediction of an outcome, I think a mediator has to be candid and say, no crystal balls here.
I think John wants to jump in here.
Well, I'll tell a story because it triggered a recollection of a matter that I had where I had to really struggle with the decision. But there was a motion for summary judgment pending in a matter, and it was having a huge impact on the mediation, as you can imagine. The court hadn't ruled. We didn't know when the court was going to rule. And so just by asking a number of questions to one side, the in-house counsel suggested that I thought that his client, his company, his employer was going to lose. And so I had to be very careful in how I answered that. but then we had to adjourn because people had to get on airplanes. And he said to me, would you write a memo to me summarizing why you think the court's going to rule against us? And so I struggled with how to answer that question. I ended up saying that I would, and I did. And so I wrote the memo explaining what I thought the court would do and why. But it couched it in language that obviously this is for their consideration. I was simply gathering both law and facts that had been presented to me and organizing them. And we were scheduled to have a call the following week. And then the court issued the summary judgment order an hour before the call. And when we got on the call, the case did settle following the entry of the order, but the lawyer that I sent the memo to asked me if I had sent my memo to the judge, because the court's opinion mimicked, not quite word for word, but pretty close, everything I had written in the memo as to what I thought was going to happen. So it's one of those situations where, you know, you have to make a decision as to what you think the best thing to do is at the time. And I don't normally answer the question, you know, what's my opinion? I will deflect that with a response that turns back to the client's lawyer, that, you know, raises questions as opposed to trying to provide an answer. But this goes back to what Rich was saying also about evaluative versus facilitative. You make and try to make good judgments at the moment about how to help the parties without crossing any lines in your mediation training. And so, but, you know, but I've done things like that. In another situation I had, a lot of money was at stake, and I was in a hotel room in New York where I had a portable printer and listening to the parties all day. Overnight, I drafted a mock summary judgment order and printed it and gave it to one side the next morning and said, here, take a look at this. And if you can't find a flaw in it, you really ought to consider offering more money. They did, they couldn't, and then they did, and the case settled. So, I mean, and I didn't get a lot of sleep that night because that was literally a district court order to form, looked just like the judge had written it. And there was no motion pending at the time, but I was trying to illustrate to them what the flaws were in their argument. And that seemed like the best way to do it, is to give them a mock order and then let them try to tear it apart, and they couldn't. So, you know, you're always trying to make, and I deal with a lot of sophisticated parties, so it's a slightly different situation than what some mediators might be dealing with, where a party may not really be sophisticated at all. So, you know, you can take some risks as long as you don't cross lines. So I'll just leave it at that.
Okay, thank you. And Stephanie, please, I know you've been waiting.
I have some thoughts, and I agree with everything that Rich said. And John, great story. I'm highlighting and agreeing with everything you said. I want to just put a little bit more of a spin on what the opinion talks about with the unsophisticated parties, right? Because you are dealing with sophisticated parties. And let's see if I'm allowed to do this right now. I'm going to do a quick little whiteboard. But what I've often thought was one of the hardest ethical tensions that we have is that on Riskin's grid, for those of you that are familiar, you have evaluative up here, right? And facilitative down here. And when someone asks us, what would you do, right? The same answer that you would give with an attorney in the room might not be legal advice. But with an attorney in the room, it might not be legal advice. But with an attorney not in the room, a self-represented pro se or pro per, it is legal advice. So is this bizarre tension that pro ses ask us in terms of our sense of wanting to help to become more evaluative in a certain way, and yet the ethical rules require us to be more facilitative. So the answer to that question, what would you do? And because we're trying to protect here against this line, which is either the unauthorized practice of law or forming the attorney-client relationship, that's kind of what's being protected here and what 518 is talking about in many ways. And so for me to answer that question, what would you do? We have some guidance. California clearly allows in the court rules, which I could go into, but I think people are probably not interested in that, but clearly allows me, if it's in the shadow of the law about a case, to talk about an evaluation of the case. Now, if the attorney is in the room, it's much easier than if the attorney is not in the room, I think. Now, if we're talking more broadly over here about what would you do, as a mediator, I am allowed to have opinions and preferences, right? So if they're asking me a question about what would you do? We've all been taught in mediation training, first day 30 years ago, at least this was standard orthodoxy, it doesn't matter what I would want, but what do you want, right? And I do think it is permissible to allow a mediator to discuss the interest. And this is different than advocating for interests under the rule, right? But in our lay meaning of the word interest, to discuss with people their interests. I'm hearing you are questioning that. I'm hearing that your diagnosis is getting in the way. Like we all know, litigation is trauma. Like it is trauma, it just is. So, for most people, right? So I'm hearing you say that your diagnosis is also getting in the way, that this litigation is getting in the way of you being able to. I think if that were the case, I'd have to be thinking really seriously about these things. So I do engage with parties, and I don't think there's anything in 518 that prevents us from doing that. And that's what the overreading of the opinion was. I mean, we can ask the authors, but I don't think they were trying to prevent mediators having any conversations with people about their non-predictive legal interests, non-legal interests. And I have a lot more to say about it, but I'll stop. I promise.
Sure. No, I thought Stephanie did a great job identifying and highlighting the tension that can arise, particularly with unrepresented parties and misperceptions as to the mediator's role. That's very, very important. The opinion itself does not preclude a mediator from offering predictive views as to how a tribunal might rule. Having said that, I think Rich's cautions are very appropriate and wise, that courts can come out any number of ways that are unanticipated, not really predictable, and would terribly embarrass the mediator in some circumstances. However, there are some standards out there that suggest that mediators should first confirm with the party that they're giving informed consent before that evaluation is given. And I think that's a fair middle ground to stake out, because sometimes once you've given the prediction, it can't be taken back, and especially you may learn more and different information as the process goes on that could affect that prediction. But then, it's sort of set in stone once you make it. So I think Rich's cautions were spot on. Thank you.
Thank you. And we've had a related question come in from a colleague with extensive experience, like many people here, asking, do the panelists find that using the skills that are taught in Introduction to Mediation, into that 40-hour course that people in so many states are familiar with, that those skills are sufficient for resolving every case? Is Mediation 101 sufficient, Rich?
So if you take a 40-hour cooking course, doesn't mean you're getting a Michelin star. I'll just say that. But do you need to know some basic things first before you start to become, a professional at atomized cooking? Sure. So a sufficient first step is a 40-hour course. But is that where sophisticated practitioners stop? I think not. We do 8 to 10 different new programs a month just within our organization. And these are people who have been mediating for decades. And, something changes, like, Rule 518 comes out and we get together and have a discussion about what that means. So, does a great 40-hour course provide everything that you need? Well, I hope not, because that would make every advanced negotiation and mediation course out there seem to be redundant. So no, it's we're talking, and Danny and I talked earlier about, our profession is composed of a set of distinct sub-disciplines that include psychology, human behavior, some sociology, economics, game theory, law. There's so much out there that, like I say, I've been at this for scratching it 4 decades, and unfortunately, my reading list just gets longer. So 40 hours is a good start.
So
But
I
that's all
know
it is.
that John and Kathleen will want to jump in a second, and I'll simply add, Rich, that as a follow-up, I'm wondering if the spirit of the question is something like what John was talking about when he referenced the idea that everything we need to know we learned in kindergarten, right? Or maybe to state it differently, when you're doing the 10th, 11th, and 12th follow-up advanced training, do you find that maybe like we've seen today, that you're touching on those same values that people begin to study when they're in the 40-hour training?
Okay, so not all 40-hour trainings are created equally, and some of them do delve into some things that I think are super fascinating, like for me, cognitive and behavioral psychology. And so when I learned from Amos Tversky the idea that we are risk-seeking in the domain of losses and risk-averse in the domain of gains, and there's an asymmetry there, well, that just matched up with my life experience, that one insult seemed to wipe out 1,000 compliments, right? So I kind of knew, for me, learning that was like, that's a good name for that. Now, the advantage in understanding that cognitive and behavioral psychologists have studied things that resonate with me, the advantage to that is I know that what's going on now is something that is universal among our species, as opposed to my eclectic experience in the world, because I will distrust my eclectic experience until I find out that it's broadly shared. So for me, the corroboration that we see when we read big longitudinal studies, that our experience is consistent with that of our colleagues out there and the other humans in the world, I think makes us more confident as we move forward that we're saying something that has some kind of external validity and is not just based on, what happened to us. So I do think advanced training makes us more confident that the lessons we learned in kindergarten are the same, whether we were brought up in Pasadena or Provincetown.
Very nice. Thank you. Let's bring in Kathleen. Kathleen, during this, you haven't had a chance to jump in recently, and let's bring John in as well. You're the one who brought in the kindergarten concept, but Kathleen, please.
Thank you. I would add that it also depends on what other training you have. So, for example, in Philadelphia County Court of Common Pleas, we have a Commerce Court program, and that's one of the programs where I get asked to be either a special discovery master or a mediator. So you have to go through special training through the Commerce Court program. In addition, if you're serving as an arbitrator in Philadelphia County, you also have to have had so many years of experience, as well as go through another program before you can be certified to serve as an arbitrator. In addition, I think that not only looking at the court programs, federal court has similar criteria. But I think you also need to look at the person's other credentials. And, for example, the Commerce Court program, a lot of people in Philadelphia, Pennsylvania, a lot of people know who I am because of my past bar service as president of the Pennsylvania Bar and also as the chancellor of the Philadelphia Bar Association. So I have a lot of credibility with people from both sides of the aisle to handle these types of cases. So I think you have to look at the individual as a whole. And it's not just taking a course or two, it's also what other experience do you have? What other courses have you done? And does the legal community respect you? And will they respect your opinions? And of course, I'm not giving opinions when I'm serving as a mediator, but will they respect what you say and what you do? I have to be careful, right? Because we wrote that down earlier on in this presentation.
So
I-
I'll just add this in response to the question. The answer is no. You can't always settle cases entirely based on what you learned in the 40-hour course. Rich said he's been around the block a couple of times, having practiced law for 4 decades. Well, that's why I'm so tired, because I'm now past my 5th decade practicing law, and I draw on my experience all the time, not just what I learned in the mediation course. So you have to draw on your experiences when you're helping parties resolve a case. So it's not just what you learned in the mediation course.
Okay, so we are not quite yet, according to John Barquette, providing 40-hour training credit for kindergarten. There is more that needs to be considered. Stephanie, I saw that you were going to jump in.
Well, I don't know that I think that's been said, and I so agree. But I see with our time, I did want to kind of point to where I think some of our ethical rules need additional development and coaching. And Rich talked a little bit about that. I don't know, am I allowed to veer off in that direction?
I
So
think if Professor Stephanie Blondell determines
okay,
it
I'm
to be
going
on
to.
topic, it is on topic. And
It is on
as
topic.
Stephanie
Well,
indicated, we're nearing the end. So everyone, please, our panelists, please start thinking about a thought that you want to leave everyone with. Stephanie, go ahead.
And so maybe this is me doing that. So as 518, I think really raised some interesting issues. In section 1, that duty to disclose and discuss with people our role was presented, but for me, teaching a clinic in a court-annex situation, message given does not equal message received. And so I think there's a really interesting ethical question in there, particularly with pro se and pro per parties where you've explained it 3 or 4 times and it's still not being received, and yet capacity is still there and the right to contract is still there. So there's some really interesting questions there. I think the legal information, legal advice question, we should further define that section 2 of the opinion. We should do a better job, I think, defining that. And what I think is interesting about this is the opinion starts to define what that is from mediator behavior. And I'm not so sure that's the way we should do it. I wonder if it should be defined from a subjective test in terms of the party rather than from the behaviors of the mediator, which this opinion follows many states in doing it that way. I'm not sure on that yet. That's just a thought. It's not an opinion.
So thoughts for future discussion
right?
With apologies to make sure we get a final thought from everyone. I'm going to jump
okay,
in.
and that's it. Well, that was it.
And that's it. So again, with apologies for jumping in when that was it. Let's please, panelists. Tom, would you share a final word or two of wisdom?
I would simply thank everybody and hope that they find this opinion, this guidance to be useful in their practice, either as a mediator or as an advocate. Thanks very much.
John, Kathleen, Rich?
I get to go next. I want to remember to be neutral at all times when I'm serving as a mediator and never imply that I'm looking after any party's interest, and I'm there to help them resolve the case.
Thank you.
Thank you.
And so from my perspective, I follow the philosophy that it's always the right time to do the right thing. And so when you're serving as a mediator, if you just remember what's the right thing to do under the circumstances, you can't necessarily be guided by anything other than your experience, your training, your judgment. And if you follow your nose and you live true to that saying, that's always the right time to do the right thing, I think you'll be fine. This this opinion won't get in the way of you being an excellent mediator.
The right time to do the right thing. Rich?
Be grateful. We're in a great profession. Be humble. We get to serve. Be a lifelong learner and keep on reading. There's so much to know.
Good advice. And this is a great profession. It is an honor to be part of it, and it is an honor to get to hear and learn from each of these panelists. By way of concluding, and again, thank you so much, and thank you to everyone who's here. I got a direct message from someone who could have easily been on this panel, someone who knows this profession well, who, in the context of conversations about this opinion, sent me the message that goes, quote, "Thank you, I feel much better. Thank you, I feel much better." And to sit down and get to talk and hear how each of you on this panel sees it with your extensive experience, and to say, to get to conclude with thoughts like it is a great profession and it is always the right time to do the right thing in the context of sophisticated discussion, in the context of sophisticated engagement like we've had today, it is really, really a wonderful thing. And I find myself wishing we could have more time and not knowing exactly how, but wanting to predict at the level of feeling, at the level of my own personal opinion, that these conversations will continue and that they will continue to bear fruit for our profession. So I want to again thank everyone here and say until next time.